We'd like to turn the floor to Tom Irving, who is no stranger to this program. He has been a perennial speaker since the very beginning of this 19-year journey at Howard. Tom has some 45 years of experience in IP and really needs no introduction. And if you've attended this conference before, you will know that he is one of the most dynamic, educational, and entertaining speakers in patent law. So with that, I'm happy to turn the floor to Tom.
Oh my goodness, I'm charged up. I'm usually quite phlegmatic. I'm usually a wallflower, but I'm charged up today. First of all, I discovered that this is the 19th annual program. Esther and Latif, we were there on day one. So that means that we started this program when Esther was 12. She is a child prodigy. And so now here's my formal announcement. I'm retiring on April 29th, 2053. And that will allow me to still be at the 50th annual IP and Social Justice CLE program. I think at that point, Esther will be 35. So it'll all work out. It'll work out. The other thing I've learned today from Chip, I want a trademark. I want a trademark on basically the legal hammer from Mars. That's what I want. So Chip, I'll talk to you about this. I want you to do pro bono. I don't want you to charge me, but I want you to do this. And I've just been invited by Steve Jamar. He says, I can come even after I retire in 2053. Heck no, Steve, man. When I retire, you're on your own. So that's not going to happen. So the other thing I learned in preparing for this talk is I have 16 grandchildren. I got married when I was 10. And basically, one of my grandchildren came to me the other day. He's a budding humorist. He may be the Mark Twain of the family. He said, Grandpa, why do people not like atoms? And I said, well, I don't know. He says, because they make up everything. Well, I'm going to do my best not to make up everything today, but I think the courts and PTAB, they've all beaten me to it, and this is going to be bad. Now, Tashia, I am an electronic moron. Are you able to put my slides up? I just tried to share my screen, and it appeared to be a disaster. I'm not sophisticated like Chip. I'm not one of these trademark people. So if you can put my screen up, that'll be great, but that's not going to stop me because I learned long ago, I've been doing this for 46 years, always have a paper copy with you. Have a paper copy. So our first slide says U.S. Supreme Court affirmance of CFC decisions. And it turns out that, well, if you look over the last 8 years, you have about a 25% chance Supreme Court will affirm the Federal Circuit. Why is that? They don't like the Federal Circuit. They think they're uppity. So any chance they get to take a whack at them, they do. Now, the next slide is the Supreme Court, and the simple word, the simplest word in the English language is A, right? A, that's it. That's the whole word. And so in the Supreme Court, well, look at this, we are rolling. Okay, great. If you can go to the slide 4. Oh, thank you. Thank goodness you've got a brain and I don't. But I don't resent it. I just admire it. And so here, remember when people are all upset when Gorsuch and Kavanaugh were going to be promoted? Oh, they'll always vote as a block. They'll always do everything the same. Well, they can't agree what the word A means. So Gorsuch and Kavanaugh spent 42 pages bitterly attacking each other as to whether A meant one or did it mean more than one. Now, what does that have to do with patent law? Nah, I'm just spitballing here. I'm making it all up, but it does, and we're going to have a polling question on that. So when you say A in a patent claim, do you mean one or more? Do you mean only one? Blah, 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 blah. We're going to get more into that. Now, let's go to the next slide, please. And so here we have one of the great failings of the AIA. I'm a pretty bitter critic of the AIA. The people that worked on this, they don't like me very much, but there's other good and valid reasons for that, not just this. But basically, it turns out these PTAB judges, one of whom is a son-in-law of mine. If you have enough children, you know, you got people in every field. And so it turned out he's unconstitutional, which I take great delight in bringing up around the Thanksgiving dinner table. Hey, unconstitutional, pass me the turkey. And so the Arthur's case said, well, no, these PTAB judges, no, they were improperly appointed, but we're going to fix it. We're going to fix it because, you know, the Supreme Court always fixes everything, right? And every case that goes to the Supreme Court, I don't know about you, if it's a patent case, I shudder. I think, what evil will befall us? And so here they say, well, yeah, but we're gonna fix this. We're gonna say that, gee, you can go back to the director, and the director can revise the decisions, and the director can do whatever she wants to do. Now, I don't know why we don't have a director. Why don't we get Director Vidal confirmed? I think she's great. Why don't we get the next Supreme Court justice confirmed? I think she's great. And, politicians of all stripes, they just befuddle me. I think I would call them atoms. And so basically, we don't have a director. And so I got a case where we won at PTAB. And just before the briefs were due, the other party authors came down, the other party said, this was unconstitutional. We want director review. And so the thing spun around forever. And it finally went down and director review was denied. So what did they do? They ain't stupid. They're really clever lawyers. They challenged the director review. They said, well, he's not the right person. He's not the director. He may be the acting director, but that and 6 bits will get you whatever 6 bits will get you. We shall see how that comes out. Next. Now, this next slide, Astro Stop has been around for a long time. Usually, the asinore, the person who signs the patent can't then come back if sued and say, oh, it's invalid. Well, Minerva versus Hologic sort of upheld that. They sort of upheld that. And they said, but really it depends on the applicability, you see in red there, of the doctors tied to representations made by the asinore. So basically, if you are foolish enough to assign the patent and represent everything's valid, all these claims are just perfect, I don't think you're going to be able to challenge. That's going to be, I think, Astro Stop. And so this has got people scurrying about when they assign patents now. Look at the language carefully. Now let's go to the next great quagmire in patent law 101. The train is off the trolley. Now we have American Axles, claims of manufacturing and shaft assembly. That's not statutorily eligible subject matter. I give up. That's why I have my thinking hat on constantly these days. One, so you don't have to see me very well. And two, because is the world gone mad? And so 101, I feel like I'm just going to hunker down until that goes away because it is one screwed up piece of law. All right, the next slide. Now, the affirmative rate by the Federal Circuit, don't lose at district court, don't lose at PTAB. Because look at these numbers, they're not pretty. These numbers show that basically over 3/4 of the time, district court appeals get affirmed. And then I also got in mix, so it's even more than that. And then PTAB IPR appeals, even more. So it really puts the onus on the PTAB litigators and the trial court litigators of the bar. Win, baby, win. It's not the greatest thing in the world, but it's so far ahead of whatever's in second place. And, you're just going to have statistically a difficult time. Now, if you go to the next slide, I like to make things look like pumpkin pie, speaking of Thanksgiving. And so here's a little thing that Stacy Lewis, who is my co-author on these slides, came up with. So this shows the case outcomes for IPR appeals, breaking it down, not PGRs, but IPRs. Oh, by the way, if you subscribe to the blog, Managing IP Today, look at today's article on stats about IPRs and PGRs. They are fascinating. And, the Fintech Case comes up, we're gonna talk about that. ExParty Reexam comes up, we're gonna talk about that. Very, very cool. So, but anyway, we look at this, and I'm going to be old and stupid, but I can still add 66 plus 9 is 75. So at least 3/4 of the times in IPR appeals, you lose in the FWD. Your chances aren't good. And I think that if you lose and the client says, oh, let's appeal, why don't you just give them these stats? I feel clients should always be apprised of what are the pros, what are the cons, et cetera, et cetera. Okay, next. Now, here we have the concept on the next slide of inventorship and ownership. And this just never goes away. And so the key case is Mergenthaler versus Scudder. That case came down in about 1890. It's still the leading case in the area. But here, this is a great case. And you see the slides are whacked, but that doesn't matter. These cases stand alone. And do you realize I gave lectures for 35 years without PowerPoint presentations? It's not a big problem. And so in this case, this is the only time I know where the Federal Circuit had to, I think, near as I could tell, supervise a fist fight. Because evidently there was this Miss Wagner. She came up with a safety vest for children. Mr. Ashline was developing his product. Well, they started to talk. They had a falling out, and evidently Ms. Wagner and Ms. Ashline, it's a little bit murky in the decision, but they may have come to blows, or there may have been some hair pulling going on. I don't know, but it wasn't pleasant. So anyway, Mr. Ashline, he goes ahead, he files his patent, and Ms. Wagner says, wait a minute. That's my patent. I should be a co-inventor. I should be on here. And of course, if she didn't make an assignment, she is essentially, she's a co-owner of the patent. She could even abandon the patent if she wished to do so. I got a big case going on right now. It gets in and, spare the drama. But when you're doing due diligence, look at inventorship very, very hard. And if someone has been dismissed, inquire of the target why they were dismissed. And then also say, were they fired? I asked that question. The answer came back, yes. That led to some very, very exciting things. Patent law isn't boring. Anybody, I got a granddaughter at Harvard. She won't be a patent lawyer. She says it's boring. That's why she's at Harvard, not Duke. There's something missing there. That's all I got to say about that. Okay, let's go to the next case. Next slide. So here's more inventorship things. So Bio-Rad versus the ITC. Bio-Rad says, hey, I co-own those patents based on assignment provisions that the named inventor signed while they were employees of Bio-Rad. Wrong, because they didn't make the invention. There was no conception. There was no conception until after they had left. So that didn't work and they lost. Okay, let's go to the next slide, please. Claim construction fundamentals, still very, very important. I have concluded that I am maybe the worst teacher in the history of U.S. patent law. I've taught for over 40 years. I thought I taught claim construction. People don't get it. They still don't get it. They still continue to mess this up. So here we've got the Simo case. They say, oh, you're in the claim a plurality. Now, a plurality, that's a pretty fancy word of A, B, C, D, E, and or F. And so then the question is, does plurality require that each one of those be there? What does that goofy and or mean? You know, what's going on here? And the district court said, well, no, the plurality only requires at least two. The Federal Circuit reversed and say, oh, no. You know, they've got to be at least two of each of those things, A, B, C, D, E, and F. Now, I tell you, that isn't a license, a royalty-free license, patented technology. So please, and then look at the SuperGuide case, please, if you're going to get tempted to write a claim like this, stop, lie down, think about it, and put in a noun. A plurality of widgets, or even better, at least one widget. So it can be one widget chosen from, but it's at least one widget chosen from, and you don't get caught watching the paint dry, as they said in the immortal movie Hoosiers. Next slide, please. Oh, it happened. It happened. We've had a sighting. We've had a sighting in 2021. The creative posita finally appeared. Now, I've been warning about this for the last 14 years, ever since KSR said that a posita is a creative person, because before then, the posita was dumb as a rock, didn't know anything, couldn't think, reminded me of myself, you know, just a loser. But basically now, oh no, there's a creative posita. Now this, spoiler alert, this is going to be one of the biggest litigated issues in the next 10 years in U.S. patent law. I predict we're going to start having, in addition to Markman hearings, we're going to have creativity hearings. We're going to see creativity hearings, and we're going to have to decide how creative are these people. Oh boy, those of you who are patent litigators, your ticket is written. You will be employed for at least lives in being plus 21 years. I mean, it just can't get any better than this. All right, now, next slide. this is an evil and pernicious concept. Inherency has no place in obviousness analysis, but it's crept into the law. It came back up here in L'Oreal versus Olaplex. And basically in this case, they said, well, you didn't prove that the percentages were necessarily present. What? Why is that relevant? That's an anticipation standard if they're necessarily present. We're talking about obviousness. And you can go back for 50 years to the CCPA cases. And remember, every CCPA case is en banc authority because that's what South Corp said when the Federal Circuit got started. And so the CCPA said that which is unknown is not obvious. So how can anything inherent? Is this crazy? I hope this stops. Okay, next case, the Cumulus case on the next slide shows you that, well, the basic principles are still there. Motivation to combine, you got to explain it. You have to have a nexus analysis. It may require evaluation of claims as a unique combination. Well, I hope they're unique. I hope they're novel. I hope they're non-obvious. Now, here's a great thought. Blocking patents can't block themselves. Okay, cannibals cannot eat themselves, something like that. Modification may be non-obvious when the inventive concept, I thought we got rid of that in Lincoln Engineering. Oh, no. Now we're talking about the prior art. So if the inventive concept of the prior art teaches away, then it can be non-obvious. I got to tell you, this has atom written all over it. I just feel like they're spitballing here and making these things up as they go along. Many of them are true. It's truth mingled with error, as I see it. Now, I like this. Teaching away may preclude a motivation to modify. Agreed. And there's an article we wrote at the bottom if you want to read more about this scintillating subject. Okay, now next slide, please. Some more basic principles. Now, it's not going to help you to say, oh, yeah, well, this is obvious, and that's it. Assertions don't mean anything. And remember, objective evidence, it's got to be, and I think this is wrong here. It says commensurate with the full scope. I mean, I think the court was wrong. It's reasonably commensurate with the full scope. That's the standard. But there's a lot of loose language, a lot of atoms running around. Next slide, please. You are looking at an unfolding disaster. Written decision when I started working in patent law in 1975. If I said it, I got it, and I could claim it. And that was all there was to it. All I had to do was say it, not anymore. Now they're getting obsessed with the doctrine of possession. They've completely forgot the ancient and honored doctrine I relied on for years in interferences of constructive reduction of practice. People don't get it. So if you've got a written description case, don't assume that you have written description of even original claims if it's any kind of a complex subject matter. Take a careful look. Next slide. Now, the next slide, this IPR case, has really stirred up a lot of people because essentially it's a range case, and the range says 40 to 60%. Well, if you went through the specification and you've cobbled everything together, you could come up with that. But the only thing that could specifically be cobbled together with a minimum of effort, speaking of no creativity, was 48.2%. So the majority said, oh yeah, well, we'll give them a claim to 48.2%, usually that and 5 cents get you whatever 5 cents get you, but you can't get anything else. And so if you go to the next slide, Judge Lynn, he was very upset. He said, wait a minute, this basically absolutely ignores the worth of it. Now, he didn't go so far as to say, because he's a trademark lawyer, he wasn't a patent lawyer. He didn't go far to say all CCPA cases, this was a 76er, oh yes, I was in the field by then, back in the day, but they're all en banc authority. So this is really raised in my mind. I'm writing an article now about what's going to happen with the CCPA. Is it going to get forgotten? Well, how long are these going to be en banc? And it really applies to ex-party cases. CCPA didn't really get into issues of infringement. Okay, let's go to the next slide, please. Oh, I'm so happy. I'm right on time. Okay, so there's the GSK case, which is so complicated, I didn't dare put it in. And it held inducement to infringe because the generic person tried to skinny label, but it either wasn't skinny enough, or they had press releases, they had product brochures that essentially would induce infringement of the claim, and the court so held. Bitter. Divided panel, rehearing, same divided panel, rehearing en banc denied. Watch for GSK versus Teva. coming to a Supreme Court near you next year. Teva's going to have to go after that. That'll be very, very interesting. Now, the Ameren case should be very interesting. It's a district court case. I have a hard time conforming this with the GSK versus Teva. But then again, atoms make up everything. And so we'll be interested to see what happens if this case gets appealed, and we can talk about it next year. Okay, next slide, please. Doctrine of equivalence. It's still alive in 2021. And who can better illustrate that than the Olaf suit people? Now, and this isn't the Frozen movie. It's not the Frozen Olaf. It's the Olaf suit company. And here, basically, the issue, this is high tech. Is the hub part of the drum, or is it not part of the drum? Well, the district court says, oh, the hub has to be part of the drum. Federal Circuit says, reversed. First of all, you should have construed the claim before the trial. You know, we have to have these Markman hearings and claim construction hearings. Soon you'll be having the Tom Irving creativity hearing, blah, 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 blah. They said, no, no, no. The hub, it's not part of the drum. Therefore, there's no literal infringement. There's no doctrinal equivalence. Now, next slide, please. Judge Lurie, who was a patent lawyer, if you go to the next slide, please. Judge Lurie looked at this. He said, wait a minute. Oh, I'm sorry. It's back to slide 22. Judge Lurie said, well, I am really concerned. If you have to make 4 claim limitations change for DOE, what's the purpose of DOE? So if basically you're defending against a defendant, you're the plaintiff and the patent owner there asserting DOE, look at Lurie's dissent. It's a good one. Okay, let's go to the next slide, please. The Vivint case is very complicated. Not going to go through all the facts here, but this is big in the news because now there's a big issue of one of the people, Scott McCune, who I greatly respect. I think he's with Ropes and Gray. In that article today, he said, well, I think a lot of these IPRs and PGRs have gone down in relative percentages because people are now going for ExParty Reexamination. There has been, he didn't cite a source, but I'm sure Scott's right. He said 100% increase in ExParty Reexams. So again, in a theater near you, watch for more and more ExParty Reexams to challenge patents. And we'll just have to see where that goes. And then the next slide brings up kind of the other big elephant in the room, petition estoppel. Petition estoppel it's like our universe. It's ever expanding. It just keeps going and going and going and going. Now there's the next slide is the Fintech case. That's under serious attack, as you'll see on slide 26. And then we don't have fraud. We are pretty sophisticated. Doug, we do not use the F word in patent law. We use inequitable conduct because we're sophisticated. We all went to college or some darn thing. And so we have inequitable conduct alive and well. Here's the unfortunately named patent owner Belcher. I would have changed my name, but that's a matter of individual taste. So anyway, the story of this case is there's inequitable conduct. You can't tell the patent office something that's diametrically opposed to what you've been telling the FDA. That doesn't work. Now, there's more fun if you go on over prosecution latches. Go to slide 30. I think that's funny. Yes. Okay, here's a case. They thought that, oh, you know, the COVID variant is relatively mild, and so we don't need to reschedule an in-person jury trial. Well, as you know, the science has changed miraculously. You know, I'm a total cynic. I'm cynical against all political parties, and I thought it was miraculous that the science has changed in an election year. I would call that the political science changing, but now, I mean, we're not having to wear masks. That's kind of nice. They're very, very nice. So anyway, let's go now. Tasha, help me out. Tasha, help me out on this. Polling question 1. We've got 6 minutes, which is what I wanted to have. Okay, let's go to the slide polling question 1. Next slide, please. Yeah, okay. Okay, here we go. Now I'm going to read the question, and Tasha is going to run a poll. You can vote. Okay. You file a U.S. patent application before June 8, 1995. That was a big day. You don't want it to issue till the market matures and everyone infringes. So you're sitting on a potential 17 years from issuance if you can hold that pre-June 8, 1995 date. So you don't want it to issue. And so you write memos to your client telling the virtue of ensuring that issuance occurs in the undetermined future. Anybody that writes a memo like that, their word processor should be taken away from them. Don't put things like that in writing. Don't make statements that make it clear you're trying to blame. You can see. You appeal everything. You eat up those days and months. Finally, you're not just pre-AAA, it's also pre-URAA patent issues. Okay, here's the question. Is there a problem with prosecution latches? Yes or no? Oh, and there's the poll question. Okay, you get to vote. So put your votes in. Oh, I can't vote. That's too bad. Okay. And Tasha, do you see the numbers coming in?
No numbers yet.
No,
Everyone
no,
feel
the
free
audience
to-
is stumped. The audience is stumped. They don't know what to say. Maybe
We've got one for yes so
no,
far.
Oh, you got a yes? You got a yes,
Yes.
one yes. It does one yes stand alone. Evidently. Okay.
We have we have 3 yeses
three yeses and no nos.
and no nos.
Well, this was not a no-no. Okay. Got 3 yeses, and yeah, I sure would worry about that. I don't want to be there. I don't want to be there. Now, oh, somebody says they can't submit until they answer questions 2 through 4. That's weird. Did that go to everyone? It says only 4 attendees. Ouch. Ouch. Okay, let's try polling question 2. See if that works better. Okay, this is high tech. Okay, next slide, please. Polling question 2. Oh, it's right there. Oh, that's the question. But polling question 2 says, you file a U.S. application disclosing red, green, and yellow widgets. You claim only a yellow widget and the patent only issues. You maintain no combinations or continuations to pursue red or green widgets. Your competitor sells a green widget. Is there infringement under the doctrinal equivalence of your claim to a yellow widget? Yes or no? Okay, Tasha, get it out to whoever you can get it out to. Since I know nothing about this, I have no judgment about anybody just having the good faith of trying to run these things. Tasha, we're getting answers?
We have 4 yeses and 2 nos.
Oh, we've gone out to a broader group. Whoa, 4 yeses and 2 nos. Whoa. Now, you know, you can look at that and you can say, wait a minute. I think there's also a dedication, disclaimer problem here. You never claimed a red or green widget. You only put before the patent office a yellow widget. Why should you be entitled now to be able to cover a green widget? So again, I'd be, if you're prosecuting, try to avoid that kind of problem. If you're litigating, you're the defendant, I think you should look at that with eager eyes. Now, Tasha, since I'm old and female, let's go to polling question 4, because I noticed that 3 I put in was identical. Sorry. Here we go. Okay, we're back to widgets. Your patent claim is directed, and think of Gorsuch and Kavanaugh when you think of this. Your U.S. patent claim is directed to a machine comprising a widget and at least 1 surfboard. Woohoo! What a machine! The alleged infringer uses 2 widgets and 2 surfboards in its machine. There is literal infringement. Yes or no? Esther says, feel free to vote in chat. Okay, Tasha, what are you seeing?
Thanks, Esther. It looks like we have 5 yeses and 3 nos.
Whoa, I see a yes just popped up on the chat. This is big stuff. And so we have some differences of opinion there. I would say, after all my years of experience, yeah, there's no literal infringement. There's no doctrinal equivalence, because when you wanted to say at least one, you knew how to say it. When you said A, you meant one and only. And so with that, Esther, I have now disgraced the program one more time and look forward to 31 more disgraces before I retire after the 50th annual. Thank you all so much.
Thank you. You are welcome back anytime. This is one of the highlights of the year in review. And thank you for not only the educational, but entertaining overview of the year, which was really packed with a lot of different cases.